In the spring of 1969, a car went off a bridge on Chappaquiddick Island, Massachusetts. A 28-year-old woman named Mary Jo Kopechne died. The driver, Senator Edward Kennedy, survived. The facts of what happened in the hours that followed, and the hours, days, and weeks that followed those, became one of the most analyzed political crises of the 20th century. What is less often analyzed is the mechanism beneath the public story. The specific decisions made by specific people in the first hours after that bridge went down. The legal team assembled, the advisors called, the narrative structured, and then the silence that followed, deliberate and total, maintained with remarkable discipline across an entire extended family and its network for decades. Ted Kennedy remained in the United States Senate for another 40 years. That outcome, survival, continuity, legacy intact, did not happen because the scandal was small, or because the public forgot. It happened because a system was activated, a specific, learned, inherited system for managing reputational damage that old money families had been developing, refining, and passing down across generations long before there was a 24-hour news cycle, social media, or an algorithm deciding what story lives and which one dies. Today we're going inside that system, the legal architecture, the communication strategy, the social mechanics, and the psychological posture that old money deploys when everything goes wrong. Not to celebrate it, not to condemn it, to understand it, because understanding how this machinery actually operates is the only way to see clearly what's happening the next time you watch a powerful family navigate a crisis with apparent effortlessness. If you want the real mechanics behind how power actually operates, not the surface level, not the spin, subscribe now. This channel goes inside the real systems of dynastic wealth and influence every single week. Reputation as asset, the financial case for containment. Before we go inside any specific mechanism, it's worth establishing the foundational reason why old money families treat reputational management with the same seriousness and often the same budget as any other major strategic function. Reputation for an ultra-high net worth family is not a vanity concern or a matter of pride. It is, in the most literal possible sense, a financial asset, one that directly influences deal flow, investment access, partnership opportunities, the valuations of businesses the family owns, and the social capital that underpins every other advantage discussed in this channel's previous videos. A 2026 industry analysis puts this plainly. For high net worth individuals, personal reputation directly influences deal flow, partnership opportunities, investment access, and the valuation of businesses you own. It is a financial asset. This means that a reputational crisis is not merely a personal or social problem. It is an economic event, one with real, measurable consequences for every part of the family's financial ecosystem. A damaged reputation can close doors to club membership, cut off access to the deal networks covered in this channel's video on private clubs, reduce a family's leverage in negotiations with counterparties who now perceive elevated relationship risk, and, in severe cases, trigger covenants in lending arrangements that treat reputational damage as a material adverse change. This economic framing is precisely why the most sophisticated dynastic families don't treat a scandal as primarily a PR problem to be managed by their communications department. They treat it as a strategic crisis, requiring a coordinated response across legal, communications, financial, social, and governance dimensions simultaneously. And why a 2025 survey found that 94% of North American family offices explicitly treat reputation as a core strategic imperative alongside their financial mission. That's the frame within which everything that follows should be understood. This isn't about vanity. It's about protecting an asset that took generations to build and that touches every other part of a dynasty's operation. The first 72 hours. What actually happens? The immediate war room. Who gets called? First, the most important decisions in any reputational crisis are made in the first 72 hours, and old money families with established crisis protocols approach this window very differently from how most people imagine a wealthy family responding to a problem. The first call is almost never to a public relations firm. It is to a lawyer, specifically a crisis specialist attorney, whose primary job is not to manage the public narrative, but to establish what can and cannot be said, by whom, and on what timeline, before any public statement is made. This sequencing matters enormously. Anything said publicly before the legal situation is fully understood can and will be used against the family in any subsequent legal proceeding, and in a genuine crisis, a legal proceeding is almost always a realistic possibility. Crisis communications professionals who work at this level describe the correct first sequence this way. Preserve facts before speaking broadly. Stop uncoordinated communication across the family immediately. Identify all stakeholders who need to receive tailored information, and decide whether any holding statement is required to fill the information vacuum before a full response is ready. All of this happens before the family's name appears in any public statement, before any advisor speaks to a journalist, and often before anyone outside a very tight inner circle even knows a problem has occurred. In a properly prepared old money family, this inner circle is small by design. The crisis response team typically includes a small number of people: the family's principal legal advisor, a trusted senior family office executive, and a crisis communications professional, often one who has been retained on a standing basis for exactly this kind of situation, rather than scrambled together under pressure after a scandal has already broken publicly. The deliberate smallness of this circle is itself a strategic choice. Every additional person who knows the full scope of a crisis is a potential leak, and in the first critical hours, the single most valuable asset a family has is the ability to control which information reaches the public and in what sequence. The NDA architecture. Running alongside the immediate communications response is a parallel legal process that typically receives far less public discussion, but is in practice one of the most consequential tools in the containment arsenal: the rapid deployment of non-disclosure agreements across everyone with potential knowledge of the underlying situation. ND, as in crisis contexts, are not primarily the crude, coercive instruments they're sometimes portrayed as in media coverage. In their most common legitimate application, they serve a genuine and legally recognized function: protecting genuinely private information about a family, a business, or an individual from being broadcast before the legal facts are fully established, while still allowing anyone who has signed to cooperate fully with any legitimate law enforcement or regulatory inquiry. An NDA that prevents someone from speaking to the press is not the same as an NDA that prevents someone from speaking to a prosecutor, and sophisticated crisis attorneys are meticulous about ensuring the distinction is clearly drawn in the document itself, both for ethical reasons and for practical ones. An NDA that appears to obstruct justice is far more legally dangerous than the original scandal it was drafted to contain. That said, it's worth being honest about the full spectrum of how these instruments get used, because your channel's editorial approach has always been to acknowledge the uncomfortable alongside the technically accurate. NDAs have, in documented cases, been used by wealthy individuals to purchase silence from people with legitimate grievances, compensating them financially for signing away the right to speak publicly about what they experienced. Courts in the United Kingdom and the United States have increasingly scrutinized this practice, and in some jurisdictions, reforms to NDAs specifically in the context of workplace misconduct, allegations have narrowed the circumstances under which such agreements are enforceable. The legal architecture around NDAs is, in 2026, more contested and more scrutinized than at any point in recent history, a direct consequence of high-profile cases that drew public and legislative attention to exactly these uses. We're about to go into the communication strategy and the social mechanics, the parts of this system that are genuinely fascinating and genuinely counterintuitive. Before we do drop a comment, which part of this first response architecture surprised you most? I read every one. The Communications Doctrine, strategic silence and narrative control. Why old money almost never apologizes publicly. Here is one of the most counterintuitive rules in dynastic crisis management, and it runs directly against what most people assume would be the sophisticated, PR-savvy approach. Old money families rarely issue full, direct public apologies in response to a scandal, and when they do speak publicly at all, they say far less than observers expect. This isn't simply arrogance or denial. It reflects a specific, learned assessment of how reputational crises actually develop over time. A full, detailed public response to a scandal, even a sincere one, has several practical disadvantages that crisis professionals have identified repeatedly across high-profile cases. It keeps the story in the news cycle because any response generates new coverage, new reactions, and new rounds of questions. It establishes a public record of statements that can be compared, contradicted, or walked back if new facts emerge. And it signals to potential adversaries, journalists, plaintiffs' attorneys, political opponents, exactly where the family believes the most sensitive exposure lies, simply by what it chooses to address and what it leaves untouched. The alternative doctrine, one deeply embedded in old money's broader cultural preference for understatement and discretion, covered in this channel's earlier social rules video, is strategic silence, saying as little as possible, as briefly as possible, as calmly as possible, for as long as possible. A brief holding statement that acknowledges a situation without elaborating on it. A spokesperson empowered to say, the family has no further comment at this time, and mean it for weeks or months if necessary. The disciplined refusal to feed a media cycle that, if starved of new material, will typically move on to the next story within days. This doctrine has its roots in something older than modern PR theory. It reflects a genuinely aristocratic approach to public pressure that goes back centuries. The idea that engaging with public criticism on the public's own terms is itself a concession of status. You do not dignify every accusation with a response. You trust that your reputation, built over years and generations, will carry more weight than a single news cycle, and you act accordingly. Controlling the counter-narrative without creating one. What happens in place of a public response is, in many respects, more interesting. Rather than mounting a visible counter-campaign, sophisticated crisis management at this level works to quietly populate the information environment with positive, accurate material about the family that journalists, search engines, and increasingly AI systems will surface alongside any negative coverage, without those materials being traceable to the family's own communications effort. The 2026 media environment has made this more complex and more important simultaneously. Industry research from Spears Magazine's 2026 Wealth Management Index specifically identifies AI-powered search tools as a new frontier for reputation management, noting that these systems synthesize information about individuals and present it directly to users, often without those users ever clicking through to any underlying source. This means a crisis in 2026 isn't just about what a journalist writes this week. It's about what an AI search assistant will tell someone about your family in 6 months or 6 years, based on how the full landscape of available information has been shaped in the interim. Reputation managers serving high-net-worth clients in 2026 are now explicitly tasked with understanding and influencing what AI systems learn about their clients, a genuinely new dimension of the same containment problem families have always faced. The Dignified Stoicism strategy, learning from the Kennedys. The Kennedy family's response to its own series of crises across the 20th century provides the clearest available case study in what this posture looks like, executed consistently across an entire extended family for decades. What observers consistently noted about how individual Kennedys publicly handled both scandal and tragedy. From the assassinations of the 1960s through the Chappaquiddick incident, through the various crises that followed, was a specific quality that commentators repeatedly described as dignified stoicism. Not the absence of grief or acknowledgement, but the consistent, visible management of those emotions within a public frame of composure and forward motion. The family appeared to the public eye to absorb enormous shocks without collapsing, which itself became a form of narrative control, because the story of Kennedy resilience crowded out the story of Kennedy scandal, generation after generation, in the public's perception of what the family represented. This is not accidental. It reflects exactly the psychological posture this channel has covered previously as one of old money's most admired qualities: the ability to absorb a catastrophic reversal without making it everyone else's problem, which, in a reputational crisis, translates directly into the refusal to perform distress publicly in a way that extends and amplifies the news cycle feeding on that distress. The legal architecture beyond the NDA, defamation law as a containment tool. Beyond NDAs, sophisticated dynastic families maintain access to a second, distinct layer of legal tools specifically calibrated for reputational defense. Defamation law, in both its American and international variants. In the United Kingdom, defamation law has historically been considerably more favorable to claimants than its American equivalent, requiring defendants to prove that a published statement was true, rather than requiring claimants to prove it was false. This asymmetry has made British defamation law a preferred venue for wealthy individuals seeking to suppress or correct negative coverage, a practice that became sufficiently controversial that the United States eventually passed the Speech Act in 2010, preventing American courts from enforcing foreign defamation judgments that don't meet First Amendment standards. The landscape has continued to evolve. A landmark UK ruling in 2025, described in Spears Magazine's coverage of the best reputation managers in 2026 as a groundbreaking libel case, involved the unmasking of the operator of a gossip website specifically described as built to monetize people's misery, representing what the publication called a shift toward protecting privacy from a legal level. This kind of ruling matters to wealthy families, specifically because it extends their ability to pursue legal action against anonymous online commentary, a category of reputational threat that, until relatively recently, had been effectively beyond the reach of even the most aggressive legal strategy. The practical effect is that in 2026, a wealthy family facing online reputational damage has meaningfully more legal recourse than it did even 5 years ago, particularly in UK-friendly jurisdictions, creating a real deterrent effect against the most aggressive forms of anonymous online commentary, even if the deterrent rarely needs to be exercised publicly to be effective. The private settlement resolving before it becomes public. The most powerful legal containment tool of all, however, is one that works precisely because it leaves no public trace whatsoever. The private settlement, reached and concluded before any legal proceeding, becomes a matter of public record. The logic here is straightforward in principle, if complex in execution. The moment a lawsuit is filed in most jurisdictions, it becomes a public document. Journalists, researchers, and adversaries can find it, read it, and report on it. A settlement reached before any filing, during what lawyers call the pre-litigation phase, never enters the public record at all. No filing means no publicly searchable document, no court record, and, if the settlement includes appropriate confidentiality provisions, no legal ability for either party to discuss the resolution publicly. This is precisely why sophisticated legal counsel in reputational matters almost always begins with an assessment of whether a situation can be resolved in this pre-litigation phase, and why families with established legal relationships have a genuine structural advantage over those scrambling to find representation after a crisis has already broken publicly. The family whose lawyers already know the landscape, already have established relationships with opposing counsel in relevant practice areas, and already understand the family's full exposure across all dimensions, is in a fundamentally better negotiating position than the family calling a law firm for the first time under crisis conditions. The social mechanics, how old money circles actually manage scandal internally. The quiet verdict, how elite social circles judge and contain. This may be the least discussed dimension of reputational crisis management in old money circles, and in many respects it's the most fascinating. The informal social verdict, rendered quietly within the private circles that actually matter to the family's ongoing influence, which often diverges significantly from the public verdict rendered in the press. Here's how this actually works. Elite social circles, the private clubs, the recurring dinner tables, the boards of cultural institutions, the informal networks discussed in this channel's previous videos, have their own standards, their own processes, and their own conclusions about a given scandal, which may bear almost no relation to what the public reads in the media. A scandal that produces screaming headlines in the tabloid press may barely register as a significant event within the specific social world the family actually inhabits, if the underlying facts are understood by the relevant insiders to be less serious than the coverage suggests, or if the family's established reputation across decades of consistent behavior within that world carries more weight than a single news cycle. Conversely, a scandal that receives relatively little press coverage because it involves something too private or too legally sensitive to be widely reported, can produce a devastating quiet verdict within elite circles, precisely because those circles have access to information the press doesn't, through the overlapping personal networks that connect every family in a given tier of society to every other. This is the real social punishment mechanism in old money culture, not public humiliation, but quiet exclusion. The dinner invitation that stops arriving, the board seat that doesn't get renewed, the introduction that doesn't get made, the phone call that doesn't get returned. None of this is visible from outside the social world in which it's happening. All of it is felt acutely by anyone inside it. Philanthropic rehabilitation, timing and mechanism. The role of philanthropy in reputational rehabilitation is well documented enough in its broad outlines that it's sometimes dismissed as simply buying goodwill. The reality is considerably more nuanced, and getting the mechanism right is something old money families are considerably more careful about than the simplified version of the story would suggest. The Rockefeller family is again the most instructive case study here. John D. Rockefeller's public reputation by the early 20th century had been severely damaged by decades of coverage of Standard Oil's monopolistic practices, culminating in the federal antitrust case that broke the company apart in 1911. The subsequent rehabilitation of the Rockefeller name through the establishment of the University of Chicago, the Rockefeller Foundation, Rockefeller University, and a sustained program of very public philanthropic engagement across medicine, education, and the arts, is frequently cited as the archetypal example of philanthropic image rehabilitation. But here's what's actually notable about how this rehabilitation worked, because it's different from how most people imagine it. It was not fast, and it was not primarily driven by the desire to repair a damaged reputation in the immediate aftermath of a crisis. The philanthropic giving that eventually rehabilitated the Rockefeller name had begun, in earnest, before the antitrust crisis reached its peak, driven by a genuine personal commitment to giving that John D. Rockefeller had maintained since early in his career. By the time the institutional reputation was at its lowest point, the philanthropic infrastructure was already substantial enough to carry genuine weight, because it had been built over years, not assembled reactively. This is the mechanism old money families understand that most observers miss. Philanthropy works as reputational rehabilitation only when it's sustained and institutionalized, not when it's transparently reactive. A donation announced in the same week as a scandal generates cynicism. A foundation that has operated for 30 years generates credibility. And when that foundation's track record is what people find when they search a family's name, it crowds out, in the most literal digital sense, the more recent negative coverage that would otherwise dominate. This is genuinely some of the most mechanism-specific content we've covered on this channel. If you know someone who'd find this fascinating, send this video their way, and let me know in the comments, which of these containment mechanisms surprised you most? The pre-litigation settlement, the social quiet verdict, or the philanthropic rehabilitation timing? The limits where quiet containment fails, and why no discussion of this system would be complete or honest without a direct examination of where it fails and why. Because it does fail, sometimes spectacularly, and understanding those failures is as important as understanding the mechanisms themselves. The most consistent predictor of containment failure is not the severity of the underlying scandal, but the number of people who have direct, independent, personal knowledge of the underlying facts. A scandal that implicates one family member, witnessed by a small number of people who can be reached and whose interests can be aligned through a combination of confidentiality agreements and financial resolution, is the scenario this system is built to handle. A scandal that involves dozens or hundreds of witnesses, many of whom have no financial or social relationship with the family, is categorically different, and the tools described in this video become increasingly ineffective as the number of independent stakeholders grows. The digital environment has made this harder in a specific way. The speed with which information can now be shared anonymously across platforms that exist specifically outside the reach of any legal order, any single jurisdiction can enforce, has dramatically compressed the window in which pre-litigation containment is even possible. A crisis that, in 1985, might have stayed within a small circle for days or weeks while a legal and communications response was assembled, can, in 2026, be across social media globally within hours. Before any lawyer has been called, before any NDA is drafted, before any communication strategy is formulated. The first mover advantage that defines successful crisis containment in earlier eras has been significantly eroded by the speed of information in the current environment. There is also an ethical dimension to this analysis that deserves direct acknowledgement, consistent with how this channel has approached similar topics. Several of the mechanisms described in this video, NDAs, pre-litigation settlements, the strategic deployment of legal threats, exist on a spectrum between legitimate tools for protecting genuine privacy and instruments that can be, and have been, weaponized to silence people with legitimate grievances, to protect genuinely harmful behavior from accountability, and to concentrate the benefits of legal representation in the hands of people with the resources to afford the most sophisticated version of it. Courts have increasingly recognized this spectrum and have begun drawing more deliberate distinctions between uses of these tools that the law will uphold and uses it will not. Reforms to NDA enforceability in the context of workplace misconduct, expanded press freedom doctrines in some jurisdictions, and the growing body of case law around the limits of defamation, claims against good faith reporting, have all, in the past several years, narrowed the space within which even the most sophisticated containment strategy can operate without genuine accountability risk. This is ultimately the most honest thing that can be said about the system described in this video. It is powerful, it is real, it is deployed regularly by the families this channel covers, and it has real limits. Limits that are, if anything, more binding in 2026 than at any point in recent memory. What this system teaches beyond the wealthy. There's a genuine question worth asking at the end of a video like this. What does understanding this system actually offer to someone who isn't managing a dynastic fortune? The answer, consistent with how this channel approaches every mechanism it covers, is that the underlying principles, stripped of their most expensive and legally complex implementation, contain genuinely transferable insights. The instinct toward strategic silence rather than reactive public over-explanation applies to almost anyone navigating a reputational difficulty at any scale. The principle that the first call in a crisis is to legal counsel, not to a publicist, holds regardless of the size of the crisis. The understanding that sustained positive reputation, built over years, provides a genuine buffer against a single damaging event, and that buffer cannot be assembled reactively after the damage occurs, is as true for a small business owner or a professional as it is for a dynastic family. And the recognition that how a family handles its own worst moments, over time, is ultimately what its reputation comes to rest on. More than the specific content of any single scandal, more than the specific success of any single containment effort, is perhaps the deepest truth in all of this. The Kennedy family's reputation, in aggregate and across generations, survived what it survived not because every crisis was perfectly contained, but because the family's public posture across decades, stoic, forward-moving, apparently unbroken, became the dominant story, and the scandals became episodes within that larger narrative rather than the narrative itself. That's the actual long game of reputational management at the dynastic level, not a perfect defense against every crisis, a reputation so deeply established over so many years that no single crisis can define it permanently. Let's bring this together. The first 72 hours, legal counsel before communications, a small circle, controlled information. The NDA architecture, legitimate in its most common uses, contested at its edges, increasingly scrutinized by courts in 2026. Strategic silence and narrative positioning. The deliberate refusal to feed a media cycle, combined with quiet management of the information environment, AI systems will eventually surface. The full legal toolkit, defamation law, private pre-litigation settlement, the deterrent effect of established legal relationships, the social mechanics of quiet verdicts within elite circles, and the long-game rehabilitation through institutionalized philanthropy built over decades, not assembled reactively in a week of crisis. This is the system. It's real, it's documented, it's practiced regularly, and it has genuine limits, which are becoming more significant, not less, as the digital environment evolves and the legal frameworks around some of its most aggressive applications tighten. Understanding it doesn't require approving of every use it's put to. It requires seeing it clearly, which is what this channel has always tried to do. If this gave you a genuinely new understanding of how reputation and power actually interact at the dynastic level, subscribe now. We break down the real systems behind wealth and influence every single week, with the kind of honest, mechanism-level detail most content in this space avoids. And if you want to understand the philanthropic dimension we touched on in more depth, how old money uses philanthropy not just for reputation, but for legacy, tax strategy, and multi-generational governance, go watch our video on the hidden values that keep old money families wealthy for generations. Let me know in the comments which part of this system you found most interesting or most troubling. I read every one. I'll see you in the next video.